Hello, we will be discussing artificial intelligence in the patent landscape today. My name is Tiffany Miller. I'm a registered patent agent by the United States Patent and Trademark Office since 2008, and I have a PhD in electrical engineering. I've been working on various fields of inventions, ranging from biomedical science to patent software and systems architecture. Here with me is James, and he'll be going into some more details.
I'm James Klobucar. I am a partner here at Gearhart Law. I've been with the firm since 2013. My background is biochemistry, molecular biology, and chemistry. I predominantly work on patents related to formulation chemistry, small molecules, but also find myself in a little bit of everything from consumer products to litigation, trademarks, and copyrights. As Tiffany said, we are here to discuss a little bit about AI and its implications on the patent landscape nowadays. As I think many people can appreciate, AI is pervasive, you could say, in society. Every day, every hour, a new company's launching their new AI product. And so the question really comes down to what does that mean for innovation and what does that mean for patent law at large? We have a good list of questions here today that we've gotten from our clients, things that are really pressing issues in this space, and we've been able to help our clients navigate these waters, and hopefully we can kind of do the same today for everyone watching. Can AI generated inventions be patented?
If you and utilize certain AI drafting tools and you do some brainstorming, you could be introducing some details into the training modules of the AI tool that you're using. And you could try to attempt to say, hey, draft an application for me, and then it will produce some content. And if you proceed to utilize that content with the patent office as a filing, as a pro se inventor, right now it's frowned upon to do that because there have been various instances where the patent office is saying that that's not patent eligible, having a an AI tool draft the application without substantial oversight of a professional or human inventor involvement. Now, however, you could utilize some AI tools to help the brainstorming. However, there may be implications of those details being made available to the public in public storage databases.
No, that's great, and maybe for those who aren't aware how some of the AI models work, I mean, what would be the difference between a public database and maybe a more private
A
database, and how
private
can you
server?
ensure, yeah, how can you ensure that your information is not gonna be public?
Well, I think that you really don't know at the early on at this time because AI tools are so new that it hasn't been federally regulated. So it's kind of like the Wild West. You really don't know when you enter in your, great idea, your brainstorming, you enter your phrase, your invention, how to make and use it into that AI. You don't know where that information's going. And often it is stored in some kind of a database that may be accessible to others. And when I say accessible to others, it may be made available by the training algorithm to utilize in generating outputs for various other queries.
In terms of, AI tools that can be used to potentially help write or draft applications, how helpful is the AI in those situations, and what are the recommendations of using one of those tools versus perhaps, seeking someone who like yourself is a patent agent or a patent attorney?
Sure. So recently, I've been getting a heavy influx of disclosures, invention disclosures, and it is mainly ChatGPT. It doesn't say it labeled, but I know it's familiar. There's various wordings and terminologies, so I'm picking up that I'm getting a lot of disclosure from ChatGPT. The problem is that a lot of times the disclosure might teach how to use a device, for example, more from a perspective of a user. and it doesn't really teach how to make it in particular details. If it's a structural device, it doesn't teach the orientation of a first portion to a second portion. It doesn't give some those great details, and it also overlooks many of those details that may be utilized to distinguish an invention from prior art down the road. So I think that it tends to be more on the generic side, and that could be a problem.
Absolutely, and we can talk about that, a bit further. But having a complete and detailed, patent disclosure is really key for, a good patent application, particularly given that it's a first to file patent system these days. One other question, and you did mention prior art. One other question that we get a lot, because one of the first things that we do with clients typically is start with a patentability search to ensure that we believe that the proposed invention is going to be novel and non-obvious and worthy of getting a patent. And so, clients say, well, what are you going to do for a search that I can't do? Can I use AI, right, to do some of that prior art searching? And what are your thoughts on that? How does that work?
I would so in my personal experience, I've actually went into ChatGPT and I went to try it out and see, and it was completely inaccurate. It referred to patent numbers, and I did go to USPTO.gov and I checked myself, and it referred to a completely different application. So although it's outputting some data, you really need to double check, especially when it's coming to down to publications that are very important that may bar you potentially from getting patent protection.
And anecdotally, I can say as well that there have been attorneys in court filings that have used ChatGPT in that same manner. And similar to how you just said, it is essentially hallucinated cases, citations that don't
Yeah,
exist,
they
quotes that
don't.
don't match
Yeah,
up to the case.
yeah.
And it's resulted in attorneys being sanctioned.
Oh gosh, yeah,
Um,
you really need to fact check
which
everything.
which is embarrassing. I would crawl in a hole and die and probably
Oh
have to
my
give up my
yeah.
license to practice law.
It's really yeah, because then you're getting so lazy to where you're just and not even using your mind and you're just, on autopilot. And as a professional, we're registered by the United States Patent and Trademark Office. So we have a level of you know, eh, we have to abide by certain ethical and federal regulations, and it's really important that the information that is given to us is as thorough as possible. As you said, a hallucinogen or fake
Absolutely.
fake information. Like we really need to know these invention details so we can do the best job possible.
Shift gears maybe a little bit since we've been talking about patentability to the other side, which is patent infringement. And we've already talked a little bit about how AI has a number of shortcomings on the drafting side or interpreting what prior art and that sort of thing means. But is there any reliable way to use AI to draft a document that would avoid, infringing a third party IP? And is AI in its current iterations even capable of understanding what?
Right now, I'm not aware of any kind of technology like that. I would be very careful at if something did produce that because you would have to then have a professional go through line by line and fact check for accuracy. What the AI might be good for is helping with a shell template. That way, the inventor might be aware of different sections of a patent application, like the abstract or the background portion, and it could aid in that. But as far as the content that goes into those portions, it really needs to be checked by a professional.
One of the things that we get a lot and we get probably, I'm going to say almost daily, inquiries from either clients or potential clients, what can be patented itself? And everyone wants to develop their own AI model, if you will. And they're interested in, can the machine learning models itself be patented? And yes or no? And if so, what does that look like and how would one go about doing it?
They used to be patent eligible without a problem prior to the July 2024 subject matter eligibility examples that had come out. So now any type of AI training module application is being heavily scrutinized, as to, is it generic? Does it contain certain steps that distinguish from a generic implementation? It's kind of unclear at the eligibility status of some AI models. You have to really speak with the patent examiner. And there was one examiner in particular, and he said that there's a difference between improving an AI model as a technical field, making certain improvements to models as the field of technology, versus just doing things a certain way in the claimed model of your invention. So there's two different mindsets. So what the patent office is really looking at is, are you contributing to the technical field rather than a certain step in your model itself? And some of the guidelines set forth in this July 2024 subject matter eligibility examples, they do go into detail on what the patent office is looking at, and you really need to show specifically how your AI model is processing the data. So when it comes down to it, you have a data set. You're collecting data, your model is processing the data. Oftentimes, it is uh, taking that data, is being input into a training engine, and it outputs the results, and then it transmits the resulting data to the inventor in the form of, the results on a display of an electronic device. Okay, so that is in itself is now considered generic process. Collecting data, transmitting the data, and displaying the data. So the patent office is wanting to know, well, specifically, how are you training the data? And now it's not good enough just to cite off some machine learning models like neural networks. You can't just say, oh, well, we're implementing neural networks. You have to go in and say, well, it's based on, and then you have to really go into some details. Oftentimes, the inventors might not have those details. They just know that the app that they created, takes a picture of something, it processes it, and you can see the results on your mobile device. So that's kind of where we have to, as patent agents and patent attorneys, we need to go in with our backgrounds in science, technology, engineering, and we can help close the gap on that knowledge in creating applications that have a higher chance of being allowed in this field.
That's great. It was a very thorough explanation and way better than I could have.
Oh, yeah? Thanks.
Absolutely. So I think maybe one final
Mhm.
question, and try not to make it too technical, I guess, but it is something that our clients do ask because they do say, well, with all the shifts in the landscape and the guidances or the court cases, you know, how has it shifted over time, and kind of maybe what's a recent case, recent court case or a decision that's important for AI purposes that they should maybe be aware of or thinking about.
Sure. Well, you're in luck, James, because hot off the press, on April 18th, the U.S. Court of Appeals of the Federal Circuit, they had issued a presidential opinion in Recentive Analytics Inc. versus Fox Corp. And basically, what the outcome of that was, that some claims were held to be patent ineligible because that they were directed to an abstract idea using a generic machine learning technique in a particular environment without further distinguishing how that machine learning technique was implemented. So that's where the July 2024 subject matter eligibility rules are coming into play, because you need to teach a technical solution to a technical problem. You need to have a literal recitation in your specification. of the application. And many applications that were drafted prior to, it takes 2 to 3 years sometimes from the filing date to the examiner's desk where you have a first office action where you could get a 101 rejection, right? So a lot of these 101 rejections that we're receiving now were drafted without some of that critical information. But recently, this court case came up and they actually had solidified that in order for machine learning techniques to be recognized as patent eligible, you need to really distinguish that the technology truly is non-generic.
Maybe just a quick explanation, if you can, about generic and maybe what that means in layman's terms to someone who says, "Well, of course, my invention isn't generic. It can't be."
When I was talking about a system that collects data, say you take a picture of something, your cell phone takes a picture, you have an image, and then AI processes that image, and then you have, an output of results on your phone, and it could do various things. And, I'm not going into details because a lot of the client's inventions that we've been working on are highly confidential. So this is just a hypothetical, generic data that we're talking about. But, AI can go in there and it can manipulate the data to have a desirable user output. Just that in itself, without teaching how that data is being manipulated, that's really what your examiner is looking for in overcoming the 101. So you need to really think about how the data is being processed. With machine learning, you have input data and it outputs the data. And the output data could be substantially heavily processed to your desired outcome, but how is that data specifically being processed here? And you could list it out in steps, step 1, step 2, step 3. The more information that we have, the more of a likelihood we have at proving to the examiner that you do indeed have a non-generic feature.
Thank you, Tiffany, for being here and sharing your expertise, with all of us today. I found it enlightening. I'm sure the people who watch this will as well. And I hope it also highlights to anyone watching this the nuance and the ever changing landscape in this area and the need to, consult with an expert. There are things that inventors can do, on their own as a start, but I think really consulting experts, someone who has a background in, computer science, who has proficiencies with working with AI implemented inventions, is really going to be paramount to get them, across the finish line and make sure that they have, a successful patent and something that can either, be economic advantage for their business or something that they can license to a third party, and will be protectable and defensible.
Yeah, I appreciate you having me on.
Of course.
And yeah, I hope good luck to all the inventors out there. We don't want you to be discouraged at all if you have technology that you're interested in patenting, but it just needs to be approached in the right way to increase your likelihood of success.